Madame and Messieurs, allow me to begin by expressing my big thanks. I would like to thank Mr. Professor JánosBóka, Mr. Minister JánosBóka, Mrs. Dr. Katarzyna Zombory, Professor Timea Bardzo, for the invitation, for opportunity to participate in this conference. Big honor for me. I very much appreciate that. Thank you once more. Getting to the point, I think that this topic should be perceived in the first place, of course, through the prism of the competence of the Polish administrative courts. And they are, and according to the Polish constitution, they shall exercise control over the performance of public administration, in principle, in terms of compliance with the law. I think that it's rather obvious situation for the European countries. Therefore, the essence and purpose of their activity, I mean the Polish administrative courts, is actually to formulate so-called relative phrase, i.e. a statement qualifying the specific behavior of an administrative body as compliant or non-compliant with a given legal norm. To characterize these phrases, the so-called reference norms and complementary norms are essential. Of course, in my opinion, but it is connected with the famous professor of theory of law, Jerzy Wróblewski. The first type of norms form the jurisdiction and competence of administrative courts, including criteria, premises, and conditions for its judicial activity, types of judgment, and legal consequences drawn in relation to the challenged administrative acts or actions. The complementary norm refers to the conduct of public administration bodies subject to administrative court control. These norms define the substantive, procedural, and systemic basis for the challenged behavior. Thus, the complementary norm is actually a pattern of control and pattern of legal operation of public administration used by the court as a criterion in its or for its control activity. Potentially, in relation to both of these norms, there may be a need to reconstruct them in taking into account the international rule of law. And for purposes of this presentation, the international attribute means that the administrative court determines its meaning on the grounds of law binding on Poland, of course, but adopted at the supranational level, in particular in international agreements or law created by the international organizations, of course, especially the EU. The concept of international rule of law appeared in several dozen judgments of administrative courts. Against this background, I have tried, and I will try now, to characterize the context in which the judicature refers to the concept of the international rule of law. The first issue, legal basis and meaning of the international rule of law, of course, in the jurisprudence of Polish administrative courts. This jurisprudence, in particular the jurisprudence of the Supreme Administrative Court, primarily emphasizes the importance, of course, of Article 2 of the Treaty on the European Union as a source of the value of the rule of law. In at least a dozen or so judgments, this provision is invoked in close connection with Article 19, Para 1 TEU, which combines this value, of course, with the principle of effective judicial protection of rights. According to the administrative courts, referring in this respect to the views of the CJEU, the indicated general principle of EU law was expressed also in Article 6 and Article 13 of the Convention for the Protection of Human Rights and Fundamental Freedoms, and further confirmed in Article 47 of the Charter of the Fundamental Rights of the European Union. So against this background, actually the international rule of law is reduced by administrative courts mainly to ensuring the effective judicial protection. A condition thereof is a judicial independence and impartiality, but moreover, it is necessary, of course, according to the case law of administrative courts, it is necessary for judges to have been duly appointed on the basis of national provisions, but consistent with the constitutional, convention, and EU standards. The administrative court also draws attention to the special aspect of the independence of judges in the form of their irremovability. It assumes generally holding office until reaching the mandatory retirement age. On similar legal grounds, as I listed above, the Voivodeship Administrative Court in Wrocław derives a specific obligation of administrative courts in relationship to administrative bodies. Legal certainty, equality before law, and the rule of law imply that an administrative body may be obliged to reconsider a case already concluded with a final administrative decision. The reason for applying this extraordinary procedure is the requirement to take into account the interpretation of a provision of EU law relevant to the Polish case, later made by the CJEU. Therefore, one of the conditions for the implementation of international rule of law is, according to the administrative court, that the national court, and in this situation the tax authority, ensures the effectiveness and uniformity of the application of EU law. In another judgment, the Voivodeship Administrative Court in Wrocław, also this court, referred to the procedural fairness norm, which shall be respected as a consequence of democratic state ruled by law, expressed, among others, in Article 2 TEU. In the court's opinion, elements of procedural fairness are exhaustive justification of a decision which guarantees to the individual the right to effectively challenge it, as well as proper instance review under the principle of two-instance procedure and judicial review. This was the first context. Second issue is international versus national view of the rule of law, of course in this jurisprudence. Views referring to the relationship between international and national understanding of the rule of law are rarely expressed in the administrative courts. Moreover, they do not refer to the concept as a whole, but only to one of its elements, i.e. the right to court, right to trial, and effective judicial protection. In the opinion of Supreme Administrative Court, it concerns the value legally protected both in the Polish national legal order as well as in the international and EU one. In this respect, therefore, I quote, "It is impossible to perceive the existence of any contradiction, in particular an irremovable or even hypothetical one." End of quote. In the opinion of the Supreme Administrative Court, the right to court and effective judicial protection is shaped and understood in the same way by the domestic provision, the European Court of Human Rights, as well as by EU law. In particular, since the principle of effective judicial protection of rights as a general principle of EU law results mainly from the constitutional traditions common to the member states. Third issue, general sources of the administrative court's obligation to implement the international rule of law. In the first place, this obligation results from the provisions of national law, in particular Polish constitution, of course. It was clearly indicated in the jurisprudence of administrative courts, especially by referring to the constitutional concept of sources of generally applicable or binding law, which include inter alia ratified international agreements, binding also on the, of course, also on administrative courts. According to a Supreme Administrative Court, by establishing the so-called integration clause and Article 91 of the Constitution mainly, the constitutional legislator clearly sought to define the relationship of national law to the systems of international and EU law. This was done by the, difficult word, constitutionalizing of the pacta sunt servanda principle, which is imperative under the international law, and principle of direct application and primacy of an international agreement ratified with prior consent expressed in a statute, and the principle of direct effect and priority of application of EU law. An important element of the analysis of administrative courts is the issue of supranational sources and justification of the obligation of these courts to implement the international rule of law in the Polish legal system. In this regard, the starting point may be the obvious statement that Polish administrative courts are EU courts in the functional sense, applying EU law with all its consequences. In particular, they are required to take over such a function by the principle of direct effect. With this principle, the Supreme Administrative Court combines the principle of the primacy of EU law, which in turn is aimed at ensuring the effectiveness of this law. For failure to comply with this obligation, the member state is exposed to liability for damages. So, another principle forcing the necessity of effective application of EU law and the international rule of law is the principle of state liability for damages. Fourth issue, the requirement to implement the international rule of law as an element of the complementary norm, so this pattern of control. It seems rather obvious that the order to implement of the international rule of law addressed to the administrative court may be important for reconstructing complementary norms. Patterns of legal action referred by the administrative court to the controlled legal act of administrative body or judgments of lower instance court were indeed subject to determination taking into account the principle of the international rule of law, or rather its individual elements listed above. It referred to the problem, to the pattern of control of, for example, the composition of the voivodeship administrative court adjudicating on the case, the act of the President of the Republic of Poland stating the date of retirement of a Supreme Court judge, the resolution of the National Council of the Judiciary concerning an appointment to the office of the Supreme Court judge, and the administrative decision of the tax authority, in particular if it contains an exhaustive factual and legal reasoning. The indicated court's cases lead to the conclusion that the legal grounds of the international rule of law were actually co-applied with national provisions. This included, firstly, the situation of the so-called interpretative co-application, when both national provisions and sources of international and EU law constitute together a component co-creating the legal norm which was the pattern of control. But secondly, the co-applicability was merely decorative. I mean, the court referred to the sources of the international rule of law, even though, in fact, the national law provided a sufficient basis for settling the case. It was a decoration only for the court. Next issue, fifth, as far as I remember, the requirement to implement international rule of law as an element of the reference norm. This international rule of law was also an element determining the content of the reference norm, specifying the jurisdiction of administrative court. In one case, Article 2 TEU 47 of the Charter and 6 para 1 of the Convention were invoked as an argument in favor of resolving doubts as to the inclusion of the order of the President of the Regional Court regarding the suspension of a judge in his duties under judicial administrative control. In another case, a big one, Article 19 para 1 in conjunction with Article 2 TEU in the interpretation of the CJEU presented in one of its judgment became the basis for the Supreme Administrative Court's omission of a national act inconsistent with these EU provisions because this act, national act, excluded the admissibility of judicial review of resolutions of the National Council of the Judiciary on appointment to the office of the Supreme Court judge. And conclusions concerning this state of mind of Polish administrative courts judges. One, the jurisprudence of Polish administrative courts has not adopted a comprehensive definition of the international rule of law, focusing only on some of its elements. Two, due to the frequency of references, the fundamental importance in those judgments is attributed to the sub-principle of effective judicial protection of the rights of the individual, guaranteed by the independence of the courts and independence and impartiality of judges. 3. Administrative courts present an integrative approach, striving to agree on the content of the international and national meaning of the rule of law, emphasizing the lack of a contradiction between the values derived from these two orders, supranational and national. 4. The order to implement the international rule of law results both from national sources, in particular the Polish Constitution, which is open and favorable towards international and EU law systems, and from EU sources, in particular the principle of direct applicability and the principle of primacy of EU law. 5. The international rule of law is important for determining the content of the complementary norm and the reference norm in the mechanism of formulating the so-called relative phrase. In such cases, the interpretation of national, international, and EU provision is most often co-applied by the administrative courts. 6. Sometimes, however, these courts find that the provision of a national act are inconsistent with EU law and the rule of law derived from it. This leads to omission in those cases, the conflicting national regulation. Thank you for your kind attention.